Have you ever felt so mistreated at work that you were forced to quit? You might think you resigned, but legally speaking, you might have been constructively dismissed. This happens when an employer makes the work environment so unbearable that the employee has no choice but to resign. It's like being pushed off a cliff instead of choosing to jump. In this situation, the law might see your resignation as a dismissal, a firing. This is because your employer failed to uphold their end of the employment contract, not you. Imagine a workplace where your boss constantly humiliates you, or your job responsibilities are drastically changed without your consent. These situations can be so toxic that staying becomes impossible. This is where the concept of constructive dismissal comes in. It acknowledges that sometimes resigning is the only option left for an employee facing unbearable working conditions. Remember, even if you haven't been handed a pink slip, being forced out due to your employer's actions can be considered a dismissal. Understanding constructive dismissal is crucial for protecting your rights as an employee. If you believe you've been constructively dismissed, you may be entitled to legal recourse. It's about ensuring that employers are held accountable for creating a hostile work environment that leaves employees with no other choice but to leave. How can you tell if you have a case of constructive dismissal? 3 key elements must be present for your resignation to be considered constructive dismissal. First, your employer must have seriously breached your employment contract. This contract outlines the terms of your employment, including your rights and responsibilities. A breach can be a single significant incident or a series of smaller incidents that create a hostile work environment. The second crucial element is that your resignation must be a direct result of this breach of contract. This means that your employer's actions and not other factors were the primary reason for your decision to leave. It's important to establish a clear link between your employer's unacceptable behavior and your resignation. Finally, your resignation must be relatively quick after the breach of contract. This doesn't necessarily mean resigning the same day, but it needs to be soon enough to show that the breach was the reason for leaving. A significant delay between the breach and your resignation might weaken your claim, as it suggests other factors could have contributed to your decision. Understanding these key elements is crucial in determining whether you have a case for constructive dismissal. If you believe your situation meets these criteria, it is advisable to seek legal counsel to explore your options and understand the best course of action. Constructive dismissal can take many forms, but some situations are more common than others. One frequent scenario involves issues with pay. This could be anything from your employer withholding wages to significantly cutting your pay without a justifiable reason. Such actions are a clear violation of the employment contract and can be grounds for constructive dismissal. Another common situation is workplace harassment. This can include bullying, discrimination, or creating a hostile work environment based on factors like gender, race, or religion. If your employer fails to address your concerns about harassment or is even the perpetrator of such behavior, it can be considered a breach of contract. Unreasonable changes to your job role can also be considered constructive dismissal. This could involve a significant demotion, a forced relocation to a different city, or being made to work drastically different hours without your consent. Essentially, any major alteration to your job description that you haven't agreed to can fall under this category. Finally, a hostile work environment created through constant undermining, unjustified disciplinary actions, or unreasonable workloads can also constitute constructive dismissal. It's important to remember that each case is unique, and what constitutes a breach depends on individual circumstances and the terms outlined in your employment contract. Section 4. Taking action, proving constructive dismissal, and seeking legal recourse. If you believe you may have been constructively dismissed, it's essential to take action to protect your rights. The first step is to gather as much evidence as possible. This includes keeping detailed records of any incidents related to the breach of contract. Save emails, make notes of conversations, and keep any documentation that supports your claim. The next step is to follow your company's grievance procedures. This usually involves formally reporting your concerns to HR or your manager. Be clear about the issues you're facing and how they are affecting you. This step demonstrates that you attempted to resolve the issue internally. When you're ready to leave your job, it's important to resign formally and state your reasons clearly. Mention the breach of contract and how it has led to your resignation. This letter serves as crucial evidence that you were forced to leave due to your employer's actions. Once you've resigned, you can pursue legal action by filing a claim with an employment tribunal. This is a legal body that handles disputes between employers and employees. You'll need to present your evidence and argue that your employer's actions constituted constructive dismissal. Section 5. Weighing the options, benefits, drawbacks, and practical advice for employees. Deciding to pursue a constructive dismissal claim is a significant step. It's important to weigh the benefits and drawbacks before proceeding. A successful claim can result in financial compensation for lost wages, emotional distress, and damage to your career prospects. It can also bring a sense of justice and validation. However, pursuing legal action can be time-consuming, stressful, and expensive. There's no guarantee of winning, and you may have to face your former employer in court. It's also important to remember that legal action can be emotionally draining. Before making a decision, seek advice from an employment law solicitor. They can assess your case, explain your rights, and guide you through the process. Remember, gathering strong evidence is crucial for a successful claim. Understanding your rights as an employee is vital. Familiarize yourself with your employment contract and your country's labor laws. If you're facing a difficult work environment, don't suffer in silence. Speak up, document everything, and seek help from relevant authorities or organizations. Remember, you deserve to work in an environment that is respectful, fair, and safe.